The EU data protection officers do not want to prevent the release of data transfers to Great Britain, but they find the mass surveillance questionable. The European Data Protection Committee, the EDPS, still sees a need to readjust the EU Commission's plan, according to which companies and authorities are initially allowed to continue to transmit personal data from the EU to the UK for 4 years. The body of EU data protection officers includes the mass surveillance practiced in the United Kingdom among the points that required further clarifications or special controls. In the UK, security agencies have broad relevant powers. According to the Investigatory Powers Act, the IPA of 2016, the GCHQ, which operates closely with the NSA, is allowed to undertake massive interventions in technical devices. The civil rights organization Privacy International was only recently able to achieve in long-term legal proceedings that the Secret Service is no longer allowed to hack smartphones, computers, and entire networks abroad at will on the basis of general court orders using state Trojans. In this context, the EDSA also considers an independent assessment and supervision of the use of automated processing tools for the data volumes collected to be necessary. They also call for safeguards under British law when it comes to disclosing personal information overseas. This is essential for national security, especially with a view to exemptions from data protection. In the case of the USA, the ECJ once again found in its ruling against the Privacy Shield last year that laws there allow mass surveillance by security authorities such as the NSA or the FBI. The data protection standard there, therefore, does not correspond to that in the EU. On the controversial issue of the access of security authorities to transmitted personal information in the UK, the committee welcomes the establishment of a special court in the form of the Investigatory Powers Tribunal, the IPT. In this way, remaining challenges around legal protection could be better addressed. It was also an important step to introduce special judicial commissioners with the recent IPA reform in order to strengthen supervision in this area. Furthermore, the EDPS emphasizes that several other bodies in the Commission's submission should be further evaluated or monitored in the light of the General Data Protection Regulation, the GDPR. They refer, for example, to an exemption for immigrants and their consequences for the restriction of the rights of those affected, barriers to the further transfer of personal data from the European Economic Area, and international agreements between Great Britain and other third countries. The Commission concluded in February that the UK has an adequate level of data protection. After Brexit, personal information will only be allowed to flow freely between the two sites if the EU officially confirms that British standards are essentially the same as those of the community. The decisive European regulations are the GDPR and the parallel guidelines for data protection in the police and judiciary. The EDPB now also recognizes that the EU and UK data protection frameworks are very much the same in certain key aspects. The committee refers to the rules for lawful and fair processing for legitimate purposes, purpose limitation, data quality and proportionality, data storage, security and confidentiality, as well as transparency. In addition, special protection requirements for special data categories, automated decision-making, and the creation of profiles about users apply on both sides of the English Channel. Great Britain implemented the GDPR and the associated directive into national law in 2018, explained EDSA Chair Andrea Jelinek. While laws can in principle develop further, this alignment would have to be maintained, emphasized the Austrian. We therefore welcome the Commission's decision to time limit the adequacy granted, she said. A decisive factor for a yes of the inspectors is also the intention to closely monitor developments in the United Kingdom. British Prime Minister Boris Johnson repeatedly stressed that with Brexit, his government wanted to pursue a line detached and independent from the EU in terms of data protection. And that's why they really have to have a close look on that one. The fun part is, now in case of the adequacy decision, they have a closer look at the use of data protection in the UK than they ever had when they were a member. So much about that sovereignty. And if you want to stay informed, please subscribe to my channel. Auf Wiedersehen.